Okay, let's get right to it. So there was an emergency release, an emergency message release called GN04440TN177. What it is an internal document for the policy details from the POMs that was recently changed and released by the SSA into their website. And kind of a special emergency. You got to pay attention to this notice. It was released on 2/12/2015 or 2025, and what it does is it specifically goes into changes that they're putting in for the audit process on the quality review of the claimants who are currently receiving benefits. Many of you don't realize this, but you are usually after a year or 3 years or 5 to 7 years going through what's called a quality review to see if you are a quality recipient. What do I mean by that? Some of you are receiving benefits improperly. Some of you are receiving too little. Some of you are receiving too much. And some of you are going to be considered, potentially doing similar faults or potentially fraud and stuff like that. I hope not, but this is the group, Quality Review, who begins processes on that. Now, let's get into this real quick. This is from subchapter 40 of the Federal Quality Review of Disability Determinations, transmittal number 177, comma 02/12/25. Let's get into it real quick. And remember, this was released by OARO, Office of Quality Review. Okay. So if you see Office of Quality Review or OQR, that's what you have to keep in mind. This is the group that reviews you to see if you should still receive your benefits. Now, just to kind of summarize things, they did a bunch of changes. Step one added reference to GN 0440.004. They removed bullet points. They added forms, cessation or continuance of disability or blindness determination, transmittal forms. Step 7B and 8 removed discussion on use of Form 77 SSA 5524. But that's not what you're really watching this video about. What you're really watching this video is about learning essentially what is the review process that they use. Now, just so you know, the 8-step sequential process that they use to re-review medical claims, disability claimants, SSDI claimants, SSI claimants, that is a different 8-step process. However, they have a bigger overview 8-step process that we're going to go through now. Okay. So, steps of the quality review process. Let's get right into it. Quality reviewers follow steps 1 through 8 in this section as the facts of each case dictate. Number 1, determine whether the case meets the criteria for exclusion as outlined in GN 0440.004 quality review exclusion. So this is when they would exclude you from a quality review. And, let me I'm going to read them to you real quick. That way you kind of know what they are. And I'll do another video where I go into the specifics of it. But I'm going to give you the code read down. Basically, there's code 1 through 88, but it's, the codes, to be fair, they don't go to 88. It's mostly 1 through essentially 23, missing 22. And then, of course, they have like code 88 at the very end. And then there's some res judicata details. But let me give it to you either way. That way you have them. Okay. So this is, if you want to look this up, GN 0440.004. All right, let's get right to it. Code 01. So these are people who are excluded from quality review. Okay. So non-state cases selected for review if the OQR, which is the Quality Review Office, inadvertently receives a case from a non-sampled federal site, do not conduct the quality review. Code 2. Number holder attains full retirement age in the waiting period or dies within the 5 months of the alleged onset date, and no earlier onset date is possible. Code 3. Supplemental security income only, and the applicant dies prior to adjudication. So if you're an SSI person, you're applying and you pass away, then basically, prior to them finishing or doing their adjudication, then they're not going to go ahead and continue it. Code 5, number holder applicant does not want to continue development of claim, regulation basis codes M7, M8, and N38. Bottom line is, if you begin a process and you're going through quality review and you say, you know what, I'm good, I don't want to do this anymore, go away SSA, then they'll give you the Code 5 exclusion. Code 6, informal remands, pretty self-explanatory. Code 7, field office jurisdiction, whereabouts unknown. Excluded WU case from the QA or per sample when the FO has jurisdiction of the case. The OQR does not review a case that is not under an adjudication component's jurisdiction. Code 8, invalid per selection. The selected claim is a Title II denial. Okay, so Title II is like retirement, SSDI. Title II continuing disability review, a CDR, when they try to review and see if you're still medically disabled due to severity. Or Title 16, disabled child. The per samples are composed of adult initial and reconsideration allowances only. So they'll exclude in that kind. Code 9, pre-hearing CDR reconsideration cessations. That's where they, pull back the benefits. Code 10, the file contains supportable FO documentation of a substantial gainful activity or technical denial. No medical determination is needed. Code 12, Medicare-only cases when death precludes entitlement. Bottom line is some of these are going to get more complex. So I'm going to skip because there's the whole res judicata adjudication by component per only claims coming up. I'm going to do a whole video on those exclusions. That way you know exactly what they are, and I'll go through and explain them in more detail to make it easier for everybody. So step 1, see if somebody meets an exclusion. If the case is an exclusion and does not warrant quality review, enter the appropriate exclusion code in the OQR case processing system and route the closed case to the field office. If the case is not an exclusion, skip to step 2. Number 2, open and review all case documents. The order of documents review is at the discretion of the quality reviewer, meaning like when the person's reviewing your claim to see if it's a quality one, meets all the requirements, they get to go ahead and look at the documents as they want to see them. Number 3, after initial review, determine if the adjudicating component's determination complies with the regulations, the Social Security rulings, and other written guidelines such as program operations manual systems. The evidence in the case must be sufficient and support the adjudication component's determination. In other words, is the evidence there that would support the adjudicator's decision? If the evidence isn't there, there's a problem. There's a big problem. If the adjudicating component's determination is policy compliant and sufficient, OQR considers this a clean case, which, basically you got dirty cases and clean cases. That's why we have quality control. If a deficiency is suspected and the case needs additional input, continue to step 4. If the case is clean, clear the case following the procedures in the bullets listed in this section. Bullet 1, verify that all determination information is correct on the SSA 831, cessation or continuance of disability or blindness determination and transmittal, Title 16, and or cessation of continuance of disability and blindness determination and transmittal. That's the SSA 833. Okay, next one of the bullet points. Code the case processing system, effectuate the determination when applicable, date and release any notices as appropriate, and route the folder to the FO. In other words, they're saying, do all the stuff they need to go ahead and fix the thing and then get it back to the field office to go ahead and get it out of quality control so that the claim can be finished up and processed. Pam, super mega thank you for the $49.99 donation. That's absolutely amazing. Let me put a heart on that. I really, really, really appreciate that. I'm putting a like on it. That is absolutely incredible. Super, super thank you. That's amazing, amazing. Because remember, guys, this helps me buy the gear. The next piece of gear, just so you know that I'm saving up to buy, is made by Rode and allows me to have cameras set up around a table so that I can interview people and basically go ahead and click the camera buttons to switch to their camera. So like that's the next thing that I'm going to be buying based off the funds that I'm receiving so that I can actually interview and have live interviews, which is going to be a really amazing idea, but also a very scary idea because, to be very, very truthful, I do a lot of my videos live because my brain goes at 1,000,000 miles per hour and I'm, capable of doing that. A lot of people aren't like that. So there's going to be some like, oh, what's the attorney not going to ask me now? But I'm going to try and keep it simple, straightforward so they want to come on the show. But we're going to get some good people on there. Some real good people. All right. With that said, potential issues to consider. This is where their policies are telling the quality review person essentially what to consider as potential this way, it might go that way, etc. Okay. It is possible that the determination and onset for a case are policy compliant. So it's possible claims fine, but the information on the SSA 831, 832, and 833 is incorrect. In these case instances, upload a modified determination and transmittal forms with the correct information. Note any changes made in the remarks section, item 34. So what they're saying is it could be that the case is totally fine, but their final decision form is not correct. In that case, they want that they want that adjudicator to basically go in and fix and create a new decision letter that outlines the fix in the remarks section. Next one, be sure that the OQR, Office of Quality Review, processing system coding matches the information intended to appear on the determination and transmittal forms. This chair is going to break on me. Like it keeps squeaking in like bad ways. Like I can feel the little ball bearings in like the seat where it does the move things. Like one of them's not working right. The new chair's coming. It is coming. I'm excited about it. Again, be sure the OQR case processing system coding matches the information intended to appear on the determination and transmittal forms. What they're saying here is look at the transmission code number. Make sure that when you send it back to the local field office, that it makes sense for what type of claim it is. That way, in the future, it can be properly processed for an updated quality review. Next one, number 4 section. Remember, there's 8 sections to it. Determine if you need a consultation from a medical contractor, MC, or a psychological contractor, PC. Okay, so address questions pertinent to the medical issues in file using the medical referral in the case processing system. So this is the part at step 4 of this 8-step process, not the traditional 8-step sequential process, but this 8-step process used by quality review to see whether or not they need a new updated medical consultant or psychological consultant. MC is physical, PC is basically mental. It's a doctor that reviews the total file and then basically gives a summary write-up as to severity levels and likely impairment. So these people you don't ever see, the SSA hires them to give a medical opinion, but they also certify them to have, basically this, magical certification that their opinion means a lot because they went through some sort of SSA training to have the MCPC title. Okay. Address questions pertinent to the medical issues in file using the medical referral in the case processing system. Now, some of you don't realize, but as you sit there, over time, your file will collect medical questions of quality review. Questions about, whether or not this type of evidence, shows improvement, whether or not, you've done something you shouldn't be doing, whether or not you should be doing something that you're not doing, etc. So what happens is they have an AI system now since 2023 that's creating basically a map of questions to show that you might be or might not be essentially, bottom line, a quality disability claim. All right, now let's keep rocking and rolling through this. Issues that often require review by an MC or PC include questions regarding the sufficiency of evidence, onset date, evaluation of medical opinions, and assessing the accuracy of the symptom evaluation completed by the adjudicating component. See GN 0440.130 for more information regarding medical review policy. I'm going to do a whole video on that one because that one stings. Like, a lot of people don't realize how they're going to get stung by that one. But let me, do I have a pen on me? I don't have a pen on me. Yeah, I do. Here we go. Let me go ahead and I'm going to circle that one and go back to it because that one's going to take a whole video. And let me tell you, like, if you want the secret to the keys to the castle of how they medically go after you, they're right there. Note, when the quality reviewer and the MCPC cannot reach an agreement on the medical findings and conclusions, or both, again, when the quality reviewer and the MCPC cannot reach an agreement on medical findings and conclusion, or both, meaning like the reviewer doesn't like the claim for some reason, or basically the medical reviewers, the medical consultants are like, I don't know if this is matching up. They don't look this severely disabled. This is what they do. Expressed in the formal assessment, that assessment must remain in the official claims folder, even when it is contrary to the final conclusion made by the quality reviewer. In that situation, quality reviewers must prepare a rationale explaining why the medical findings and conclusions, or both, in a specific medical assessment are not reflected in the final disposition of the case. In other words, the assessment contains incorrect conclusions. It does not address issues that need resolution. Okay. So bottom line is that's something that pops up. Let's just take a little walk over to GN 0440.130. I want to kind of give you some of the bullet points from that. That way you have them, because honestly, let me get you at least started on this stuff. That way you're good to go, because a lot of you don't realize, and I know it's mostly people from, that were found disabled way, way back, like 10 plus years ago. And they're like, if you're disabled, you'll be found disabled again over and over. Everything's wonderful. Don't worry. You're severe enough so long as you think you're severe enough. And if I think you're severe enough, you're severe enough. Everything's great. Those people tend to live in Lulu La La Land. But, reality is it's a totally different program now, totally different palms now. It's a different world. Let's go through it real quick. All right. Under this particular rule, MC and PC review criteria. So this is where basically they're required to have medical review, where they are required to review you to see if you're a quality medical claim, quality disabled person. Okay. The reviewer is required to obtain a review by a medical consultant or psychological consultant for, number 1, any case with a group 1 medical deficiency, unless the file contains no medical evidence or the case is a continuing disability review case without any current medical evidence. Number 2, any case or workload required per instructions from the Associate Commissioner of the Office of Quality Review or designee. In other words, if they're reviewing somebody from higher up, Associate Commissioner says, go take a look at this claim. They got to send an MCPC and have them look at the record. Number three, any case with an OQR assumes where the OQR assumes jurisdiction. So basically, they got to put one, have medical consultants go ahead and review the claim if the Office of Quality Review assumes jurisdiction over it. Now, discretionary medical review occurs if review by an MC or PC is not required, right? These medical consultants, reviewers may use their judgment in deciding whether to seek medical consultation. Number one, the reviewer may, that's not must, may obtain review by an MC or PC in cases with questions or issues regarding impairment severity, inconsistencies in the evidence, the claimant's ability to sustain a normal workday or work week, medical improvement, durational onset, end, or cessation dates or closed periods, whether the medical evidence in file is sufficient, symptom evaluation and limitation to function, psychiatric review technique, the PRT, residual functional capacity, the RFC, or mental residual functional capacity, MRFC, assessments. Okay. So remember the psychiatric review technique, the RFC, the MRFC, these are all things that assess your ability to do things on a daily basis based off of, basically following so many steps, interacting with others, being able to go ahead and complete so many tasks, that are lined up to complete something. All right. So with that said, now let me go through. The reviewer generally does not need to review by or input from an MC or PC for cases with the following: clear evidence that the individual is engaging in substantial gainful activity, right? So they're going to look into that and potentially come after you if you go past your 9-month trial work period and your 3-month extended eligibility period. Incorrect determination regarding vocational factors, incorrect determination regarding onset relative to Title II eligibility period, incorrect determination regarding collateral estoppel. There's a bunch of stuff here. I have to do a whole video on this because this is too much right here just for that video. I want to get through these 8 steps though. That way you understand specifically what they're looking for. Number 5, determine if any type of deficiency is present. And you don't want a deficiency. Deficiency is like you're marked. You know what I mean? That's like worse than a red flag. Red flag's like, hey, go look at this claim. Deficiency is like, a big ass flag, not a little one, a BA flag. All right. So, okay. If any deficiency is present, continue to the steps listed in this section. All right. Deficiencies fall into 3 categories. So this is where you're not in a good spot. 3 categories. Group 1 deficiencies, as defined in GN 0440.202 and 203, have the potential to reverse the determination from unfavorable to favorable or from favorable to unfavorable. So if they wanted to change you receiving benefits where you were going to gain them or potentially lose them, they would use group 1 deficiencies. Now, I think I have over here group 1s. Yeah, I think I have it right here. Let me just read to you basically the general bullet point categories so you know exactly what's going on with it. And then we'll go through, let's see, I think this is, what is this? This is 0202. So it's 0440.202 and then 0440.204. So let me go through the categories. I'm not going to go into detail because I want to get through this in a relatively good amount of time. All right, here we go. Number 1. So basically, you have a deficiency. You have a big flag, not just a cute little red flag, but like a big flag. Like there's an opening door into your claim situation. If you have substantial gainful activity, if you have impairment severity issues, if you have duration, has your impairment lasted 12 months issues, if you have medical improvement, if including whether medical improvement affects the ability to work, if you have medical improvement exceptions regarding whether the individual has benefited from advances in medical or vocational therapy or technology. So like if you go get surgery and you're better now, or you're doing like a therapy and the therapist is like, well, I want to get more money from the insurance. I'll just say this person is improving, but there's still work to go. You're going to fit into subcategory 5 here. 6, medical improvement exception regarding successful vocational therapy, right? That's number 6. 7, medical improvement exception regarding newer improved diagnostic techniques or evaluation shows the individual's impairments is not as disabling as it was at the time of the most recent prior favorable medical determination. They're going to nail you on that one. And remember, medicine is changing a lot. And I have a thing. I'm going to go into that one more. That one scares me a lot because we'll do that later. Because remember, this video is just about the 8. Number 8 on this list, medical improvement exception regarding a prior determination made in error. Let me read that one to you because a lot of people aren't going to understand how it could be made in error. The adjudicating component applied, right, the thing that decided the claim, or should have applied the medical impairment exception in a CDR regarding a prior determination made in error due to error on the face of the record. There was some problem, there's some mistake. Missing required material evidence. The evidence that that was used to adjudicate the finding disabled isn't there, or something is missing from it. New evidence related to the prior determination or decision. Like, let's say that they have something that comes in that disproves, basically that you were the disabled person that you claimed you actually were. Next one, medical improvement exception regarding a prior determination based on fraudulent circumstances. So you got fraud, functional capacity changes, evaluation of vocational factors, right? That's where they look at the age, education, transferability of skills, ability to perform past relevant work, and ability to perform other types of jobs in the national economy. Failure to follow prescribed treatment, okay? So you remember how I kept hammering on you guys and being like, look, you gotta, you know what I mean? You gotta pay attention to this particular thing. Please pay attention to this particular. Remember how I kept like harking on you and snarking on you? And I was like, yo, heads up, buddy. By the way, what's going on? All right, so this one. Failure to follow prescribed treatment, an adjudication component, meaning that they could put you through quality review and remove your benefits or change your favorable to unfavorable. So adjudicating component, allowed or continued disability for a claimant who should have been denied or ceased because the individual failed without good cause to follow prescribed treatment. So let me give you an example of that. Let's say that you were supposed to go get a surgery, but you didn't get a letter that said you can't get the surgery because of some other impairment limiting the ability to do the surgery. Then you could get nailed by this one. This is category 21. Question or notice or piece thingy right here, number 12, failure to follow prescribed treatment. It's the FTFPT category 21 option. Next, denied or ceased disability for claimant who should have been allowed or continued because the individual had good cause. So again, really important. A lot of you will get prescribed medications and then you'll just drop off, not get them anymore, not use them. And your doctor will be like, how's the medication? You're like, oh, it's great. That's fraud. Or you'll be like, picking up the medication, and then if they have a way to test it, and it doesn't pop up in your system when they do a blood test, and then they're like, hey, where is this? You're supposed to be on this, and that's not following prescribed treatment. They can get you on that one. Next one, drug addiction and alcoholism. You guys know about the DAA materiality assessment. Next one, onset of disability, right? The adjudication component allowed at Title II disability claim despite an established onset date, EOD, after the date last insured. For example, if you're insured up to severely impaired after your date last insured, they're going to kill the claim with that one. The field office documenting the certified electronic folder with the correct DLI, prescribed period, or childhood disability claimant's date of birth. So let's say the local field office screws up what your actual date last insured is supposed to be, then they can pull back your benefits on that one. Or evidence indicating an earlier onset date is not supported. Okay. So basically, where they look at it and they're like, you know what, it doesn't make sense that we approved them all the way back to this date. We should have approved them forward to this date, right? Next one, 15, adoption of prior administrative law judge or appeals counsel finding under an acquiescence ruling. There's no time for me to go through acquiescence rulings, but I will do that in another video. The adjudicating component erroneously adopted or should have adopted a prior ALJ or AC disability decision or specific finding, impairment severity, RFC demands a PRW. Not enough time in this video to go through that, but it is number 15. Number 16, collateral estoppel. The adjudicating component incorrectly adopted a prior final determination and disability cannot be established based on the current evidence in file, meaning you had a prior claim. The judge went back too far into that prior claim where you denied and didn't appeal it, so can't go with it. There's a lot of stuff here. I'll do specific videos on those. I have the section 0440.204 up as well. That goes into onset dates, ending dates, cessation dates, stuff like that. I'll go into that in another video because I'm sure you guys want to know what they can use to go ahead and remove your benefits. All right, so that's Group 1 deficiencies and Group 2 deficiencies. Let's head over to... Okay, now there's another part, Section 3, which is important. Technical corrective actions, TCAs. We're not going to have enough time to go through that, but basically if there's a non-compliance or procedural requirement or something technical wasn't done right, then they have to go ahead and fix that. And that can sometimes change whether or not you can receive benefits. Another one, substitute of judgment. We don't have time to go through that one. Let's get to 6. Provide a clear and concise explanation of the deficiency. So now we're all the way at the point where we're at the clear and concise explanation of the deficiency to the adjudicating component and request or take corrective action. So this is where they're summarizing down why they found a problem, what they're going to do about it, whether or not you're going to get to keep your benefits. If taking corrective action is appropriate, correct the claim and follow the procedures in step 3 of the quality review process. If taking corrective action is not appropriate, code the case processing system to reflect why the case is not policy compliant. Control the return and continue to step 7. 7. Send the case back to the adjudicating component. Prepare a summary of the case, including an explanation of why the case does not comply with the policy. Notify the adjudicating component when applicable of the deficiency and the required corrective actions as follows. Number 1, use the request for corrective action function in the OQR, Office of Quality Review case processing system, to return cases with Group 1 or Group 2 deficiencies or TCAs which may affect the disability determination or the period of disability to the adjudicating component. Number 2, use the SSA's request for case action function in the OQR case processing system to provide feedback about TCAs to the adjudicating component. So they have 2 systems that they go ahead and let somebody know if there's a deficiency in your claim, and therefore it's not a quality claim, it's not a clean claim, they may potentially remove your benefits. Now here's the final one. Number 8, when the adjudicating component corrects the deficient case or completes a required development and returns the case to OQR for review, the quality reviewer should reevaluate the full case record, ensure that the adjudicating component has made the requested corrections, determine if the case is now policy compliant. Further, corrective actions are needed by the reviewing component, or if a subsequent return is warranted to the adjudicating component, as explained in G0440.205. If the case is policy compliant, clear the case following the procedures outlined in step 3 of this section. So in other words, if there's a problem, they got to outline it, and they put you in another section where they do a review to go ahead and cause you a shitload of bleeping problems. However, if it's policy compliant, everything's good, cool, you get sent back, case is cleared, comes out of basically, their ramp of, or rather their grouping of cases to be reviewed, you're done, you continue forward. All right, so bottom line is that, I'm going to read to you some of the basics here. The Office of Quality Review conducts a federal quality review of disability cases and OQR review components located in 10 regions and OQR Baltimore. The OQR review components were formerly called disability quality branches. Okay. Just so you know, quality reviews, federal quality review of adjudicating component disability determination provides general quality review processing instructions for review components to use when returning or correcting deficient certified electronic folder CEF cases. All right. So with that said, I need to go through that in more detail. I need to go through each category in basically, an assessment to explain to you all the little things that they normally look for. Now, I think what would be really good is if I use my brain from all the claims that I've done and put down subcategories of types of evidence that they normally look for to tell you about what they normally look for, you not being a quality claim. What a lot of people, and this is, again, the people who were found disabled 10 plus years ago, they live in that la land of like, as long as you're severe, you're going to be severe for life. Everything's hey, what you have to keep in mind is this, very important. The systems that they use are constantly getting more aggressive at reviewing things in your file. If you don't have updated medical evidence where you're doing, benefit upkeep, then you are going to get reviewed more aggressively. 2025 is a heavy flow review year because of 2024. 2024, Commissioner Martin O'Malley switched a bunch of people off of reviews and put them onto processing initial disability claims. As a result of that, he then said, okay, at the end of 2024, going into 2025, we're going to ramp way up all these reviews. So I just want to make very clear that you understand that you are all potentially going to be reviewed this year, because this year they had to bring all those employees back over to doing these reviews. So I just, be aware that's what's going on. All right. So I will catch you all a little bit later. You have a wonderful, wonderful, amazing night. We're about to head right back into the week. With that said, please remember to like and subscribe and head over to Disability Resolution on Google. Type in Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there if you like. I always like seeing those. They kind of get me pepped up. With that said, I go live on Mondays and Thursdays. Also, there's a mini contract below in case you want a private 1-hour session. I will catch you all a little bit later. You have a wonderful night, and I will see you next week. All right, sleep well, and we'll catch up soon. Thanks so much. Bye-bye, everybody. Bye-bye.